Hi, my name is Goldman, and I'm an attorney with Goldman Associates. And today I'd like to talk to you a little bit about the divorce process and outline that a little bit for you. A lot of people want to know what they can expect in the context of their divorce. Well, you have to understand, folks, a divorce is a litigation. A divorce between two people is someone suing someone and asking for relief. So you're going to get all the benefits and all the burdens of a standard litigation. There's going to be the filing of a lot of papers. There's going to be a discovery process. There will probably be subpoenaed documents. There will be depositions taken if necessary. There's going to be court proceedings. There's going to be a long life cycle of this case, just like any other litigation. Your standard divorce case with children is going to run you a minimum of 6 months and probably go 6 to 9 months easily if there are any issues at all. So you sort of need to be aware as you go through this process that that's the general time frame. Now, what's going to go on? Does a person need to actually physically go to court in the case of a divorce? And the answer is, for the most part, lawyers can handle certain things. If you're out of state or out of the country, a lot of times the court will give you sort of dispensation and waive your personal appearance and allow participation remotely by telephonic communication or other such means. But you got to understand, in the normal, average, standard case, a litigant appears before the front of the court and before the court itself many times during the context of a divorce, particularly if there are motions involved, if there are issues regarding children, if there are show cause proceedings. A person can expect to physically have to be in the courtroom. At least that's the model that has gone on for many, many years up till this point in time. Before you get involved with this, you may want to ask yourself, what are the things that I should look for or do before I hire a lawyer? Well, before you hire a lawyer, I think it's important to get some direction from an expert in the field. So what you should be doing is you should be contacting your attorney and you should be saying to them, look, is there anything that I need to do to protect my assets, as an example, before we file? So a lot of times people ask us this, and we'll tell them, if you've got joint assets with your husband or wife, and you're concerned that they're the kind of person who might, despite you, go into the account and clear it out, well, then you better make some maneuvers in order to limit the accessibility. You might, for example, let's say you have $10,000 in an account and your husband has equal access. You might take 5 of it, which is your half, so to speak, and move it to your own private account. That way, if he decides to liquidate an account, he liquidates his half and not yours. This is important. The same holds true with credit. If they're joint credit cards and you're concerned that your spouse may run up a bill and then get you stuck paying half of it during the divorce, then you might have a conversation with Visa or MasterCard. Find out what your options are. Can you cut down your credit limit? Can you separate it out between husband and wife so you're not liable for that? That might help you as well. So these are the kinds of things that you want to talk to lawyers about. Another thing, for example, you might want to do is, since you're probably going to end up splitting, for example, 401k contribution, you might, rather than max out the 401k during the divorce proceeding, you might want to limit that. Make it as small as possible, because every dollar you put in, it's arguable that 50 cents of that is going to the other person. Do you really want to fund that account and make it greater and greater, all the while it's going to be split later on down the road? So maybe you don't want to do that. You might want to suspend or limit contributions in that regard. So that's an important kind of thing that you should be thinking about, and you should ask your attorneys about that. Now, here at Goldman Associates, there are certain things that we do that are specific to us. Number one, we like to give our clients, before they even hire us, this sort of pre-hired consultation, which tells them things that they might do to get the ducks in a row so that when the proceeding starts out, they don't get burned. That's very important. We also give people some coaching about what they should do with respect to children in order to firm up a later custody battle. That's very important. One of the most important things that we provide our clients is the benefit and experience of over 30 years of practice and familiarity with the judges and the courts. So when you contact us and you sit down and you follow our format, both before we get involved and afterward, you are far likely to have a much, much better result following that format. Remember one thing, our particular format and how we handle custody and divorces, that's something that's been honed over a period of over 30 years. You get the benefit of that. You get the benefit of that the moment you walk in. Even though your case is brand new, we still bring to the table all the experience that we have and all the shortcuts and all the maneuvering that we're able to do within that system to help you in your case. If you have any questions about that or when you're ready to get started, come back, give us a call, circle back, and we'll be happy to help you out.